On 19 November 2019, the Federal Court made a landmark decision that left a profound impact on the housing industry. It decided on whether the controller has power to grant extensions of time for delivery of vacant possession in respect of properties under the Housing Development Act 1966. That case was known as Ang Ming Lee and others versus Menteri Kesejahteraan Bandar, Perumahan dan Kerajaan Tempatan. The decision in Ang Ming Lee led to many purchasers filing actions against developers. Eventually, some led back to the apex court in the case of Obata-Ambak Holdings Sdn Bhd versus Prema Bonanza Sdn Bhd, wherein the court clarified the impact of its earlier decision. That was on 26 July 2024. In this video, we explore what were the key points, including some points that are commonly misunderstood from the Ang Ming Lee and Obata-Ambak. In Peninsular Malaysia, Parliament enacted the Housing Development Control and Licensing Act 1966 with the intention of regulating the housing development industry through control and licensing of housing development and protecting purchasers. Now, being a social legislation, it was designed with the protection of the purchasers in mind, as Parliament recognizes the unequal bargaining position between a developer and an ordinary homeowner, the latter of which may not be conscious or aware of his or her legal rights. At the time, the HDA does not contain any provisions to standardize the contract for the sale and delivery of a housing accommodation. Before we can continue with the topic, it is worthwhile to explain what are the differences between an Act of Parliament, which we normally refer to as an Act, such as the HDA, and a regulation, such as the HDR. Adopting the Westminster model of governance, the Federation of Malaysia is divided into three branches of government: the legislature, the executive, and the judiciary. The fundamental principle of this model is a separation of powers wherein the legislature makes law, the executive implements the law, and the judiciary interprets the law. This is consistent with Article 44 of the Federal Constitution 1957, which states that the legislative authority of the Federation shall be vested in Parliament. Though fundamentally it is Parliament who makes the law, there are instances where Parliament has delegated its powers to the executive to make the laws. This may come in many forms or instruments, and they are collectively known as subsidiary legislation. Under Section 3 of the Interpretation Act 1957, these instruments are made only through the powers under the relevant Act, which are known as the Parent Act. Therefore, all things done under said subsidiary legislation is deemed done under the Authorizing Parent Act. Now, logically, a subsidiary legislation only draws power from an enabling Parent Act. The earlier instrument must not only be within the confines of the Parent Act, it should not be inconsistent with the same. Section 23 of the Interpretation Act 1957 says that where a subsidiary legislation that is inconsistent with an act, it shall be void to the extent of that inconsistency. To put that into today's topic, the HDA is the Parent Act. Under Section 24 Sub 1, Parliament expressly gave powers to the Minister to make regulations for the purpose of carrying into effect the provisions of this Act. Of relevance to this article, subsection 2C states that these regulations prescribe the form or forms of contracts which shall be used by a licensed housing developer, his agent, nominee, or purchaser. And subsection 2E says that the regulations regulate and prohibit the conditions and terms of any contract between a licensed housing developer, his agent, or nominee, and his purchaser. And so, in exercising powers under Section 24 of the HDA, the Minister created the Housing Development, Control and Licensing Regulations 1989. And this regulation came into force on the 1st of April 1989. It was via the HDR that the government streamlined and standardized the sale and purchase agreements for housing development. This is found in Regulation 11 of the HDR. Subsection 1 says, every contract of sale for the sale and purchase of a housing accommodation, together with the subdivisional portion of the land appurtenant thereto, shall be in the form prescribed in Schedule G. And where the contract of sale is for the sale and purchase of a housing accommodation in a subdivided building, it shall be in the form prescribed in Schedule H. It was thereon that every housing developer must utilize the SPAs in the prescribed form, either Schedule G for landed housing accommodation or Schedule H for subdivided or stratified housing accommodation. Both Schedules G and H have Clause 23 Sub 1, which provides that the time in which the developer must deliver vacant possession of the property. For Schedule G, it is 24 months from the date of the calendar. Both Schedules G and H provide, under Clause 23 Sub 2, that in the event the developer fails to deliver the property within the time stipulated, then the developer shall be liable to pay the purchaser liquidated damages at 10% per annum of the purchase price from the expiry of the delivery of vacant possession until the actual vacant possession. Since the intention of Parliament was that the HDA and HDR are to be the protection of the purchasers, the courts have held that it was not open for the developers to amend any of the terms of the SPA under Schedule G or H without the authorization of the controller. This was as early as 1982 by the Federal Court in SEA Housing Corporation Sdn Bhd versus Lee Po Chu. That position has been consistently followed even until the recent decision in the Court of Appeal of Loh Tina and others versus Kemuning Setia Sdn Bhd and others. It says, Regulation 11 sub 1 of the regulations is crystal clear in that the SPA in the prescribed form and in the case Schedule G is to be used for the SPA. There is to be no waiver or modification of any of the provisions of the contract of sale unless there is a certificate in writing granted by the housing controller for the waiver or modification as provided under the Regulation 11 sub 3 of the regulation. The requirement is so strict that there shall be no approval of an application for a waiver or modification if such an application is made after the expiry of the time stipulated for the handing over of the vacant possession under the contract of sale as spelled out under Provisor 11 sub 3. Now, this is where the heart of the controversy is at. Regulation 11 sub 3 of the HDR provides that the controller may, if he or she is satisfied that owing to special circumstances or hardship or necessity compliance with any of the provisions in the contract of sale is impracticable or unnecessary, waive or modify such provisions. Now, on the plain reading of the said proviso, it appears that the regulation has given the controller the power to waive or modify any of the clauses in Schedule G or H, including modifying the time for delivery of vacant possession under Clause 23 sub 1 of these said schedules. Here are the brief facts of Ang Ming Lee. Mr. Ang entered into an SPA for the purchase of a condominium known as the Sri Istana Condominium. As stated earlier, number 1, since it is a subdivided residential unit, the SPA has to be in the prescribed form under Schedule H of the HDR. Number 2, Schedule H of the HDR provides that vacant possession must be delivered 36 months from the date of signing of the SPA. Number 3, it also provides under Clause 25 sub 2 that the developer shall be liable to pay the purchaser LAD if the developer fails to deliver the vacant possession within 36 months. In the midst of construction of the condominium, the developer, BHL Construction, applied for an extension of time for the delivery of the vacant possession of the units to the purchasers. As stated earlier, it was pursuant to Regulation 11 sub 3 of the HDR. At first, the application was rejected by the controller. BHL then appealed to the Minister of Housing and Local Government pursuant to Regulation 12 of the HDR. The minister purportedly allowed BHL's appeal and granted an extension of 12 months, thereby giving BHL 48 months from the date of signing of the SPA to deliver vacant possessions of the unit to the purchasers. Because of this, the purchasers could not claim for LAD. They challenged the minister's decision by filing for a judicial review in the High Court. That case went all the way up to the Federal Court, where it was held, among others, that number 1, controller has no power to waive or modify any provisions in the SPA under Schedule H, as Section 24 of the HDA does not confer power on the minister to make regulations for the purposes of delegating to the controller the power to waive or modify Schedule H. Number 2, Regulation 11 sub 3 of the HDR, which empowers the controller to waive and modify the SPA, is ultra vires the HDA, meaning it exceeded the authority given under the HDA. Why did the Federal Court decide so? Firstly, power was given to the minister by Parliament to regulate and prohibit the terms and conditions of the contract of sale. Neither Section 24 nor any provisions in the HDA conferred such powers to the controller. The roles and power of the controller granted by Parliament are contained in other sections of the HDA and purchase agreement, but it does not include the power to regulate and prohibit the terms and conditions of the contract of sale. Therein lies the inconsistency between the parent act and the regulation. Secondly, and this is central to the decision of the Federal Court, nothing in the HDA conferred the minister with the authority to delegate his powers to the controller. The court held, by Section 24 sub 2e of the Act, the minister is empowered or given the discretion by Parliament to regulate and prohibit the terms and conditions of the contract of sale. As opined by the learned authors in the Smith Judicial Review, a discretion conferred by statute is prima facie intended to be exercised by the authority on which the statute has conferred it, and by no other authority, but the presumption may be rebutted by any contrary indication found in the language, scope, or object of the Act. In our view, Having regard to the object and purpose of the Act, the words to regulate and to prohibit in subsection 24(2)(e) should be given a strict construction in the sense that the minister is expected to apply his own mind to the matter and not to delegate the responsibility to the controller. The Act, being a social legislation, is designed to protect the house buyers. The interests of the purchasers shall be the paramount consideration against the developer. Parliament has entrusted the minister to safeguard the interests of the purchasers, and the minister has prescribed the terms and conditions of the contract of sale as per Schedule H. We find no contrary indication in the language, scope, and object of the Act that such duty to safeguard the interests of the purchasers may be delegated to some other authority. The legislative intent that the duties shall remain with the minister may be discerned from Section 11 and 12 of the Act. Under Section 11, whilst the controller is given the power to investigate on the reason why a licensed housing developer is unable to meet his obligation to the purchasers, or is about to suspend his building operations, or is carrying on his business detrimental to the interests of the purchaser, it is the minister who is empowered to give directions and to take such other measures for the purpose of safeguarding the interests of the purchasers and for carrying into effect the provisions of the Act. Likewise, under Section 12, which provides for the powers of the minister to give general directions as he considers fit to the licensed housing developer for the purposes of ensuring compliance with the Act. Such directions, which shall be given in writing, are binding on the developer. Thus, when the developer made Regulation 11 sub 3 of the HDR, he had delegated his powers under Section 24 sub 2(e) of the Parent Act to the controller. That powers were conferred specifically to him and no other by Parliament. This, according to the Federal Court, was ultra-virus, meaning it had exceeded its authority. What this means is Regulation 11 sub 3 of the HDR is no longer good law. A controller has no power to waive or modify any of the provisions under Schedule G or H of the HDR. In Ang Ming Lee's case, the extension time granted and applied to his SPA was unlawful, and he was entitled to liquidate the damages for the delay of the delivery of the handing over of vacant possession of his unit. Ang Ming Lee was decided on the 26th November 2019. Since that decision, many purchasers had brought cases against developers for late delivery on account of extension of times by the controller being invalid. Eventually, some of these cases reached the federal court and was heard together. There were 3 such cases. The first of this case was Obata-Ambak Holdings Sdn Bhd versus Prema Bonanza Sdn Bhd. In this case, Obata is the purchaser of a condominium known as Central Residence. Prema Bonanza is the developer. Like in Ang Ming Lee, Prema Bonanza applied to the controller under Regulation 11 sub 3 for an extension of time for the delivery of the vacant possession. The controller granted the EOT on the 16th of December 2010, extending the delivery of the vacant possession from 36 to 54 months. Now, what is peculiar in this case is that at the time of granting of the EOT on the 16th of December, Prema had not executed the SPAs with the purchasers. Obata only had entered into the SPAs on the 11th and 18th of July 2012. Thus, when Obata entered into the SPA, it had already contained the amended extension of time. In this case, clauses 25 and 27 of the SPA in Schedule H of the HDA provided that the vendor shall deliver the parcel and the common facility respectively within 54 months rather than 36 months from the date of the SPA. After the decision of Ang Ming Lee, Obata commenced an action against Prema Bonanza for LAD, arguing that both clauses 25 and 27 were invalid and that the EOT granted by the controller was void following Ang Ming Lee. Now, at the High Court, Obata's claim was struck out because at the time when the development was launched or when the controller had granted the EOT, Ang Ming Lee was not decided yet. It was also struck out because Obata was time-barred from filing their claim. Under the Limitation Act of 1953, Obata must commence their suit within 6 years from the date of the cause of action. Since Obata's claim is premised on the amendment to clauses 25 and 27 of the SPA, it was held that the time starts to run from the date of execution of the SPAs, which means Obata had to commence his action before the 10th and 17th of July 2018. Obata only commenced the suit on June 2020. Thus was held to be time-barred. Obata appealed to the Court of Appeal, but the High Court's decision was upheld. Then there is a second case of Prema Bonanza Sdn Bhd versus Vignesh Naidu Anak Lelaki Kupusami Naidu, which involved the same projects as Obata's. The facts are somewhat similar to Obata's, only that in this case, Vignesh's SPA was entered on the 18th of July 2012 for his unit. Like in Obata, Vignesh's claim for LAD was struck out at the High Court. However, unlike Obata, the Court of Appeal reversed the High Court's decision and allowed vacatious LAD. Unlike Obata, however, number one, the Court of Appeal held that Ang Ming Lee would apply retrospectively, meaning the controller's decision in granting the EOT in 16 December 2010 was void and of no effect. Number two, Vigneous' right to claim for LAD only arose on the date he accepted delivery of vacant possession of his unit. Since he was deemed to have taken vacant possession of his unit in early February 2017, he was still within the limitation period. And finally, there is Sri Damansara Sdn Bhd versus Tribunal Tuntutan Pembeli Rumah, and in this case, two co-purchasers entered into an SPA for the purchase of a condominium unit in Foresta Damansara. The SPA contained a clause that vacant possession of the unit will be delivered within 42 months from the date of the SPA. The purchasers filed a claim in the Homebuyers Tribunal for LAD, which the tribunal allowed. The claim was adjusted but upheld at the High Court and the Court of Appeal. All three cases were heard together in the federal court as they all dealt with the reverberations of Ang Ming Lee. The first issue is when does time starts to run. In both Obata and Vigneous, the federal court dealt with the issue as to when time started to run. It was held, for the purposes of limitation, time starts to run from the point in which the cause of action accrued. In both cases, the cause of action was premised on whether clauses 25 and 27 of the SPA were valid or otherwise. In this regard, the cause of action accrued at the time when they executed the SPA, since the extended time of delivery had already been incorporated into the SPA. That was the earliest point in which Obata or Vigneous could have commenced an action against Prema Bonanza. Since time started to run at the time of execution of the SPA in this instance, both Obata and Vigneous' actions were time-barred, and therefore their claim must necessarily fail. Whilst time in Obata and Vigneous started to run from the date of SPA, that does not mean in every case involving the invalidity of extension of time by the controller under Regulation 11 sub 3 of the HDR would run at the point of execution of the SPA. That is a misreading of the federal court's decision. The court says time starts to run from the point which the cause of action accrued. In Ang Ming Lee, for instance, the cause of action did not accrue at the date of the SPA since EOT had not been granted at the time. In that case, the minister only granted the EOT much later on. It was only then that the cause of action accrued. The second issue, can you claim LAD against the developer without attacking the controller's decision? In Sri Damansara, the developers argued that when they extended the time for delivery of vacant possession, they had relied on the fact that the controller had granted them an EOT. And as this happened before Ang Ming Lee, they had no reason to doubt the validity of the controller's decision. Before the federal court, this was framed as the second actor theory. In other words, what is the effect of the Sri Damansara's action of extending the date of delivery of vacant possession, which is the second act, which is based on the controller's exercise of granting an extension of time, which is the first act, where the later was subsequently held to be invalid. The second actor theory was applied in a 2006 case known as Pan Wai Mei versus Sam Weng Yi and another. In that case, the appellant was one of the owners of a property which was charged to a bank. The owners defaulted on their loan, and the bank filed for an application for an order for sale of the property. The land administrator made an order for sale by way of auction. Now at this point, the appellant did not challenge the order for sale. The respondent was a successful bidder and was registered as the proprietor of the property. A year later, the respondent applied to evict the appellant. The appellant did not attend, and an order to yield vacant possession was granted. The appellant later attempted to set aside the order, claiming that the order for sale by the land administration was a nullity. The late Justice Gopal Sriram, citing Professor Foss's view, says this: an invalid administrative act may, notwithstanding its non-existence in law, serve as the basis for another perfectly valid decision. Its factual existence, rather than its invalidity, is the cause of the subsequent act. But that act is valid since the legal existence of the first act is not a precondition for the second. But the administrative acts clearly exist, in fact, and they often appear to be valid. And those unaware of their invalidity may take the decision and act on the assumption that these acts are valid. When this happens, the validity of these later acts depend upon the legal powers of the second actor. The crucial issue to determine is whether the second actor has legal power to act validly, notwithstanding the invalidity of the first act. And it is determined by analysis of the law against the background of the familiar familiar proposition that an unlawful act is void. Justice Gopal Sriram then held that for the respondent to challenge the appellant's action to evict him, it was imperative for the respondent to have launched a frontal assault on the act of the land administrator and upon the plaintiff's registered title. In the absence of such an attack, there is no arguable defense to the plaintiff's claim. An arguable defense is sine qua non in a case as this. The Federal Court adopted Prema Bonanza and held that the purchasers in Sri Damansara cannot initiate this proceeding against the developer for collateral attack against the decision of the controller. Like in Prema Bonanza, it was imperative for the purchasers to have launched a frontal assault against the decision of the controller, which they did not do. That is why Sri Damansara's appeal was allowed. Issue 3. Does Ang Ming Lee apply retrospectively? The answer is no. The Federal Court thought hard about the ramifications if Ang Ming Lee was to apply retrospectively. The court concluded that Ang Ming Lee does not apply to extensions granted by the controller prior to that decision. As submitted by learned senior Federal Counsel Liu Horbin, amicus curiae, a retrospective invalidation of a legislation undermines legal certainty and predictability. Unless there is an exceptional public interest requiring retrospective application, an order invalidating a legislation should only take effect prospectively. The invalidation of a legislation or any provision of the legislation would have serious ramifications and implications on those who would have relied on its validity in the past. Not only be potential administrative chaos, but commercial chaos affecting the housing industry, which may affect housing buyers as well. In Boddington versus British Transport, Lord Brown Wilkinson opined he was far from satisfied that an ultra-virus act is incapable of having any legal consequence during the period between doing of the act and the recognition of the invalidity by the court. During that period, people will have regulated their lives on the basis that the act is valid. The subsequent recognition of its invalidity cannot rewrite history as to all the other matters done in the meantime in reliance of its validity. Therefore, a careful consideration of the reliance interest is not only necessary but critical. Undoubtedly, law must be given their full force and effect until they are declared invalid. An administrative decision made pursuant to a valid legislation before it is declared does not mean that the decision was void ab initio. It remains validly and legally intact. We have given our utmost consideration of the facts and the law, and we are of the view that if Ang Ming Lee is to have retrospective effect, there would be serious ramifications and repercussions to the housing developers that had placed reliance on the existing law and diligently complied with the laws which were at the time valid. With the decision of Obata-Ambak, there appears to be some level of certainty on the application exposure of Ang Ming Lee. By deciding Ang Ming Lee only operates prospectively and that the time of limitation starts to run from when the cause of action first accrued, it curtails purchasers from bringing legacy cases where extensions were granted before Ang Ming Lee. While some purchasers may look at the decision post Obata-Ambak as being pro-developer, as a whole, Ang Ming Lee has brought immense benefit to the sides of purchasers. By striking down the controller's power to grant EOT, it is very likely developers will be incentivized to complete their projects within the time period. Whether that is the case, well, the jury is still out.